Because we are a little late, I have to invite now our next lecturer, last but not the least. This is Professor Dr. Tamar Meshel, Assistant Professor at University of Alberta, Faculty of Law from Edmonton, Alberta, Canada. Her areas of expertise are international water law, international dispute resolution, transboundary freshwater dispute resolution, and international commercial and investment arbitration. Something that we all need, and we could all use your knowledge, especially when we are speaking about countries in transition and our lack of law and the other regulations. So I stop sharing now. Please deliver to us your lecture. Thank you.
Thank you. You can hear me, I hope.
Yes,
okay, perfect. So let me share my screen. You can see my slides, hopefully.
It's okay. Maybe you can resize it. That's great.
That's great. Yeah, that's okay. Okay, perfect. That's okay. Excellent. So good morning, at least morning in Canada, and thank you so much for inviting me to join you today. So as you can see from the slide and from the introduction, I'm a law professor. So the topic of my talk today is focused on the legal aspects of transboundary freshwater, namely water treaties and water institutions. But before I turn to these, I will briefly talk about why we even need water treaties and water institutions. And the first reason is that most freshwater resources in the world are in fact shared by countries. So cooperative management of these resources is key. And the second reason is that lack of cooperative management of these resources may lead and has in fact led to water disputes between states. So I will then discuss water treaties and water institutions as tools, at least from a legal perspective, that are available to manage shared freshwater resources and prevent these disputes or resolve them when they do arise. So first, briefly on the transboundary nature of freshwater resources. So much of the world's freshwater, as I mentioned, crosses state boundaries. There are, in fact, 148 states currently whose territory falls within international river basins. More than 30 states are located almost entirely within such basins. Two prominent examples are the Danube River Basin in Europe, that is shared by 19 states, and the Nile River Basin in Africa is shared by 11 states. These transboundary river basins differ greatly in size, nature, purpose, location, and they range from enormous systems such as the Congo and the Amazon, for instance, to minor streams that happen to cross political boundaries. And some have been integrated in domestic uses for their entire length, while others remain untouched by humans entirely. Some pass through developed nations, others flow through developing states. Some may be used mostly for drinking and household purposes. Some may be used mostly for irrigation, and some for industrial or hydroelectric production. So, so really the picture I'm trying to paint is there's no one solution that fits all, and every transboundary freshwater resource is very different. But they do have something in common that is common to all freshwater resources, and this is really that we're running out of it. So I don't think I need to tell anybody that the freshwater is increasingly becoming a scarce resource. And this is due to many reasons: depletion, degradation, industrialization, inefficient use, climate change, etc., etc. Now, of course, this doesn't change the fact that countries that are sharing freshwater resources are interconnected inevitably by the flow of the water that they're sharing. So, the first conclusion really that flows from that is that the use of water in one part of a transboundary lake or river or what have you is likely to affect its use in another part, quite simply, making states sharing these resources interdependent by definition. But even in the face of this interdependence and interconnectedness, if you will, of shared freshwater resources, you would expect states to be in full cooperative mode to make sure that they are coordinated in the use of these resources. But in fact, the reality is that states often behave in a self-interested manner, for instance, by unilaterally diverting rivers, by constructing dams without consulting with the other states sharing the resource, or by polluting, which may result in ultimately in conflicts. And it's popular to say that there has not been a water war, quote unquote, in thousands of years. Since ancient times, really. But in fact, over 300 freshwater disputes have been recorded between 1900 and 2017 alone, so a little bit over a century. And many of these have concerned resources that cross state boundaries. And current water disputes, for instance, there are a few that are ongoing as we speak. The GERD Dam dispute between Ethiopia and Egypt is one example, and the Silala waters dispute between Chile and Bolivia is currently before the International Court of Justice. So these cross-border disputes, when you talk about interstate disputes, they're quite unique. They're particularly common in regions where relations among states are historically conflicted and where such resources are also scarce. So of course, there's more reason for these states to fight over access to shared waters. And they're particularly complex because water issues are indivisible from other issues relating to economic, political, and national security interests. So ultimately, really what it boils down to, on the kind of the root cause of transboundary freshwater disputes, is that they're rooted in a kind of fundamental clash between the necessity of sharing water and states' pursuit of their own sovereign interests, and which of course may hinder the resolution of these disputes. And so that's what we're essentially, what it boils down to, what we're dealing with when states fight over water. But not all is lost, and not all is conflict. There is also a lot, and many say mostly cooperation rather than conflict among states at the bilateral, regional, and international levels when it comes to managing transboundary freshwater resources. And so my next slide, and I'm now getting to water treaties. Water treaties are one example, really, of this cooperation that is quite common, actually, between states sharing freshwater resources. And water treaties can be concluded essentially at three levels: at the global, the regional, and the bilateral. So at the global level, I can mention two main instruments or two main treaties in the water context. And these, because they're global, they're open for signature to any country in the world. They cannot be specific, obviously, to one resource or another. So really, they're very general in scope and set out general principles and practices rather than being resource specific. So the first example, and probably the most well-known global water treaty, is the Convention on the Law of the Non-Navigational Uses of the International Water Courses, commonly referred to as the Water Courses Convention. And this convention was adopted by the UN General Assembly in 1997. It only came into force in 2014 because only in 2014 it received the required number of signatories in order to come into force, which just showed which is quite a while. So it shows you kind of the challenge of getting countries to sign on to these kind of global treaties. It is considered the main global treaty governing international non-navigational uses of transboundary freshwater resources. It sets out basic principles for cooperation and for dispute resolution between states that are signatories. It codifies, or it has become to be known as the instrument that codifies customary principles of international water law, which I will discuss on the next slide. But still today, it only has 36 parties, state parties to it. So not too many, unfortunately, have signed on to this convention. The second example is the 1992 Convention on the Protection and Use of Transboundary Watercourses and International Lakes. It was originally European, but it has now been opened for signature to all states around the world. It currently has 45 parties, so a little bit more than the Watercourses Convention, but still not an awful lot of parties. And most of these parties are European. It's quite similar to the Watercourses Convention in its content, in setting out guidelines for states or principles for state cooperation on transboundary freshwater resources. And it does emphasize more than the Watercourses Convention, joint institutions or the creation of joint institutions in order to manage shared freshwater resources. And I'll get to joint institutions in a bit. So those are two examples of water treaties at the global level. Then there's the regional and the bilateral. So most water treaties in the world are regional or bilateral. Last time I checked on one of the UN websites, there were over 3,600 of these treaties, so quite a few. At the regional level, as the name suggests, these are concerned with water resources, freshwater resources that are shared by multiple states. So the examples I gave of the Danube and the Nile would be examples. And both of these actually have treaties or some kind of instruments that govern their use. The Mekong River in Asia is another example of a region, of a river that crosses the territories of multiple states, requiring really multi-state cooperation and treaties that hopefully all countries will sign on to and will agree on common principles that will govern their common use of this resource. At the bilateral level, you would think it would be easier to conclude treaties just between two states, not necessarily so, but two prominent examples at the bilateral level are the Indus River, which is governed, or the use of which between India and Pakistan is governed by the 1950 Indus Treaty, which till today is commonly referred to as one of the most successful water treaties, and it has survived for quite a long time. And another example, there are multiple agreements or instruments concluded by the United States and Canada to govern the many freshwater resources that cross the boundary between these two countries. And of course, whether or not two states can achieve this level of cooperation depends on a lot of things that really go far beyond just the fresh water that they're sharing, as I mentioned. What is the historical relationship between the two countries like? What are their other, maybe there are other disputes, what are their other interests, etc. And so at the regional and bilateral level, these treaties differ from the treaties at the global level because they're much more specific, right? So their substantive provisions are tailored really to govern a specific shared freshwater resource, whether it is regional in nature or bilateral in nature. But they all tend, even at the global, regional, and bilateral levels, they all really tend to contain the same fundamental principles of international water law, or at least reflect those principles to some extent. And so that brings me to discussing international water law. And time is too short to go into a lot of detail, but this is a quite vast body of international law. But to link it back to the treaties are essentially, or tend to be at some level, a codification of what are now really accepted customary principles of international water law in terms of non-navigational uses of freshwater or transboundary freshwater. And this body of law is, some would say, underutilized, but it has an important role nonetheless to play in the resolution of, and the prevention and the resolution of cross-border freshwater disputes. And it has three basic principles, if you will, that aim to ensure hopefully the effective use, development, and protection of international water courses. So I set those out for you on the slide, and I'll explain each briefly, and then some of the issues that arise from them. They're not perfect, but they can be made to be useful in preventing and resolving disputes between states. So the first principle is equitable and reasonable utilization. And quite simply, this principle requires states sharing freshwater resources to use the water that passes through their territory in a manner that is reasonable and equitable toward the other states sharing it, right? So that's just briefly what, in a nutshell, in one sentence, what this principle is about. No significant harm requires states sharing these freshwater resources to avoid causing significant harm to other states and to the environment and to the resource itself when they're using it for whatever purpose that might be. So that's the second. And these two principles are commonly considered as the substantive principles of international water law. The last one, which is commonly considered as the procedural, but I actually, in my own scholarship, take a bit of an issue with that, with calling it merely a procedural principle, is the duty to cooperate. And this principle requires states to cooperate in managing shared freshwater resources through, for instance, exchange of information periodically, as well as when there's a particular event happening with the resource, or some planned measure, notifying the other states if one state is planning some works or development or whatever have you on the shared freshwater, etc. So equitable and reasonable utilization is commonly considered as the governing or primary principle of international water law, but it's not free of issues. So first of all, the concepts of what is equitable utilization, what is reasonable, quote unquote, utilization, they're quite open to subjective interpretation. So it may well be that for each state sharing these resources, each state would have a different understanding of what is reasonable and what is equitable in the circumstances. And even though the Watercourses Convention sets out quite a few factors that should, it lists in Article 6, quite a few factors that should go into the determination of what is equitable and reasonable utilization in a particular situation or with respect to a particular resource. They cover every aspect of a transboundary freshwater resource you can think of. Geographic, hydrological, social, economic, the size of the population, and of course, above all, human needs. But there's no prioritization set in the Watercourses Convention, nor could you really, in a global convention that potentially could, hopefully would apply if states signed it, to a vast array of transboundary freshwater resources. How are you going to prioritize in advance for every resource? What are the factors that you take precedent in order to determine what's equitable and reasonable? So again, commonly considered the primary or governing principle, but it's not free of issues. No significant harm. I personally, in my scholarship, promote no significant harm as the primary principle, although it's commonly considered as a secondary principle in most international water law scholarship. So it is as simple as it sounds. No significant harm, as I said, requires countries not to cause significant harm when they utilize for their own purposes shared resources. What is significant harm lends itself to a more objective determination than concepts like equitable and reasonable. But still, states need guidance on what or how to determine what should be considered as significant harm, and thereby triggering the principles. Now, it's important to note many times when there's a freshwater resource that is shared by an upstream and downstream countries, it's a common misconception that the upstream state will always advocate for the equitable and reasonable utilization principle, because the upstream states tend to be those that develop the resource later in time. So of course they would say, well, it's our right under international water law to use this resource in an equitable and reasonable way. And what we're doing is equitable and reasonable. We are entitled as one of the countries sharing this resource to develop this resource, to build this dam, to use the waters for this or that purpose. Whereas the downstream states, it's commonly perceived, advocate for the no significant harm principle, because if they want to prevent the upstream state from going ahead with this development, whatever it may be, they will try to argue that that development causes them significant harm, potentially, for instance, by lowering the amount of water that they're receiving, or pollution, or whatever it might be. So of course, the countries have to communicate, right, and cooperate, and there's got to be a dialogue, because how are you going to determine whether a planned measure, something that hasn't happened yet, whether it stands to cause a significant harm, and therefore perhaps it needs to be rethought or replanned in a different way that doesn't cause any other country's significant harm. But don't forget, but this division between upstream and downstream is not necessarily always the case, because of course the downstream state can also engage in development, can also pollute. Any state in any location on a shared water course or any water resource can cause harm to other states by pollution. So this geographical division of these principles is a misconception. It should apply both ways. All states sharing any transboundary water resource really have an interest in all of the states sharing it in an equitable and reasonable way, and all of the states not causing significant harm to other states. So how do you get there? This is where the duty to cooperate comes in. And this is so important, the duty to cooperate in international water law, that's why I take issue with just merely referring to it as a procedural principle, which gives the impression that you don't have to comply with it, or it's less important than the other two substantive principles. And that's certainly not the case, because without the duty to cooperate, it would be very, very difficult for states to comply with the so-called two substantive principles I just mentioned. So it's crucial for states to communicate. It's crucial for them to exchange information and to notify each other of planned measures, because otherwise there is absolutely no way for them to reach any kind of consensus on whether a planned measure by one state on a shared fresh water resource is in fact, in everybody's opinion, equitable and reasonable, and whether in fact it stands to cause significant harm, or if it's already underway, or potentially already caused significant harm. So in a nutshell, this is just really the tip of the iceberg, this introduction to these three principles, but the purpose of the international water law as a body of law is to provide states with well-defined, as much as international law can do so, well-defined rights and obligations in order to allow them to manage resources and hopefully prevent, and if all else fails, at least be able to resolve cross-border freshwater disputes. And it can assist in the resolution of these disputes by facilitating interactions between states, for instance, through the duty to cooperate, because the reality is that once a cross-border water dispute has already arisen, and each state believes that its vital interests are at stake, peaceful resolution becomes extremely difficult in the absence of some kind of objective metrics, some kind of uniform legal principles that limit states' unilateral claims to fresh water that flows through their territory, right? Their ultimate temptation, if you will, is to claim that, well, the water goes through my territory, so that part of the freshwater resource that goes through my territory is exclusively mine. And that argument has been rejected in international law a long time ago. But we have to work at preventing states from kind of lapsing back into those kind of sovereignty arguments. So the last piece of the puzzle, if you will, is a river basin organization. So these kind of organizations are another common feature that you see often in water treaties, to link it back to the concept of water treaties. You see these provisions in these treaties establishing joint institutions between either regional or bilateral, or to manage regional or bilateral freshwater resources. And the Water Courses Convention, notwithstanding being global, and many other treaties provide that states may consider the establishment of joint mechanisms or commissions to facilitate cooperation and to resolve disputes. And indeed, many bilateral or regional joint water course institutions, also known as the slide shows you as river basin organizations, have been indeed established by states for the cooperative management of their shared freshwater resources. And they are usually vested with a very wide range of functions. In essence, they are vehicles for international water cooperation, essentially a vehicle to comply with the duty to cooperate in international law. They're platforms for dialogue designed really to reassure all the actors, all the states involved, that they are on the same page in terms of the rules of the game, if you will. So a few of their main functions, they remove impediments to cooperation, such as asymmetrical information, uncertainty, what's going on in with the other states sharing the resource, and high transaction costs that are involved in informing states informing each other of what is going on. They codify expectations, right? What do we expect each state to do and how they should behave? They provide information, and I remind you that is one of the key aspects of the duty to cooperate under international water law, is that states should periodically, and of course when there's a planned measure, exchange information about the water resource and what they plan to do. They can establish and impose rules, right? These rules of the game, how all the states are expected to conduct themselves. And they can even sanction misconduct if it occurs. And for me, perhaps one of the most important functions of river basin organizations is their ability to resolve disputes. And having this institutional setting already in place to carry out all these other functions really places river basin organizations or joint water course institutions, whatever you want to call them, in a unique position, or in the best position to be able to help the states that are members of these organizations to resolve disputes if they arise. And for instance, one common way to do so is by joint institutional fact-finding. It can provide states with a common database of just facts, of facts about their shared water course, and this can be immensely helpful with the resolution of factually complex interstate freshwater disputes. And this and other dispute resolution functions may be explicitly provided for in an institution's constitutive text, or it may just result from practice. Just the states will just default to the organization when a dispute arises. But most commonly, institutions' constitutive documents would provide perhaps for this institutional fact-finding, first of all, and then they could even explicitly provide for bilateral negotiations as the first step in the resolution of disputes. And some may also provide for internal arbitration, which I'm personally a fan of and advocate for, by the institution itself, or alternatively for an external mechanism, such as the International Court of Justice or an external arbitral tribunal as a second step that is a binding external dispute resolution. And then a successful example, if you will, of a joint institution that is invested actually with dispute resolution powers is the International Joint Commission between the US and Canada, which has been around for a very long time and has several dispute resolution mechanisms at its disposal, including arbitration. And I believe it's one of the very few institutions that actually has the power to arbitrate disputes between the state parties. It has not been used to date, but it's there if need be. And the International Joint Commission has been considered very successful as a river basin organization. And indeed, even beyond North America, empirical studies have shown that river-specific institutions reduce militarized conflict, increase effectiveness of peaceful settlement attempts. So certainly something that when states conclude a water treaty, they hopefully do that, as a first step, they would consider including or establishing in that treaty a river basin organization or international or a joint water course institution. So I'll end there. I'm happy to take any questions if there are any, and thank you so much for your attention.
Thank you very much for your very interesting lecture. And we